responsibilities. But you would agree with me that the MOJ did not have those constitutional and statutory responsibilities over Gilmer. As a start, I'll come back to the issue of the fact and practice.
Perhaps I would agree with you that statutorily, the MOJ did not have a responsibility, but constitutionally, it can be argued that MOJ had a responsibility. So perhaps we agree to slightly disagree.
Fair enough. But then, Council, I think soon after I admitted here that the MOJ would have failed in its responsibilities had it not communicated the order to the relevant government ministries. You did, and I commend you for your candor and honesty, you did feel duty bound, you said, to inform me that Gilmer did receive communications from the Ministry of Agriculture informing them about the court order. Is that, did I correctly understand that?
Certainly, yes.
And that's established. But what we do not establish is when Gilmer received that communication, when exactly in June.
That was not established, and I did promise that today it would be established.
And I did say that the MOJ would have written to the Ministry of Agriculture to inform them about the court order rather than to Gilmer directly. That was also stated, I believe, here, right?
Yes.
So I am assuming that the Minister of Agriculture would have only written to Gilmer as a result of the communications that they would have received from the MOJ on the court order.
Well, that assumption would not be far-fetched. However, the committee has not come across any such correspondence.
Okay. I think the Ministry of Justice can be very helpful in that. I believe that the communications between the ministry and the Ministry of the MOJ and the Minister of Agriculture should be at the ministry, certainly. But like I said, that's why I expressed my view that I would have been surprised, very surprised, if we had not written to the Minister of Agriculture. But I just wanted to establish those facts for the record before we move on. Now, with respect to your specific question on the FIU, when we received the report and the attachments showing the bank accounts and the transactions, we made a preliminary review of it, and on that basis made the decision to go to court to freeze the assets pending further investigations into the activities or financial activities of the former president. So the FIU report granted us a preliminary basis for the freezing order before we continue the investigations more substantively.
Indeed, and in that respect, the FIU report was the fulcrum of the MOJ's application.
I would say it was a significant component of it, in addition to other reports, albeit verbal, from the different state-owned enterprises that we were getting at that time.
Okay. I would like to zero in on that report. Of course, I do understand that the report is not before us, but I do understand that the report is not before us. However, I would assume that the content of the report might still be fresh in your mind, perhaps.
Let's see, depending on the questions you ask.
So, the report was obtained from the FIU through the Ministry of Finance by MOJ.
No, I received it from the late Secretary General,
I see.
Fadera. Yes.
Yes, you did say that. And so that was State House that facilitated the FIU
Well,
report.
I guess in the context of the discussions in cabinet, because whenever I was asked why nothing was being done about it, I kept insisting that I am waiting for some evidence as a foundation for any action. And so I guess in the context of cabinet discussions, the report would have been sent to the Office of the President, to the Secretary General, who then called me to inform me about it, and I didn't waste time to go and get it.
Okay. My next question would seem a bit cynical because it delves into the application itself by the MOJ. But kindly bear with me. So just put the committee through. Once the FIU report was obtained, is it that the MOJ would decipher the content of the report, or would the MOJ draft its affidavit and motion and attach the report simpliciter?
Now, that is difficult for me to answer simply because, as I said, first I was not directly involved in operational matters, not at this point yet. As I keep saying, the assets of the former president was not very high on my priority list. And so I obtained the information, shared it with my team, who worked on the motion and submitted a draft, which I looked at, okayed, and then the application was filed in court. So I do not recall really the mechanics of that application process, and simply because I was not directly involved in that operational matter at that point in time.
Okay. The reason I ask is because when you look at Honorable Chair MOJ 5A, which Mr. Tambedou is the order of the 22nd day of May 2017 by Her Ladyship, the Honorable Justice Amina Saho Sise. When you look at that order, there is an attachment referred to as an annexure. Do you have the document before you? If I could ask the Secretariat to aid the witness with MOJ 5A. Secretariat, perhaps I could borrow the witness my copy for expedience. Perhaps I can give you a second to peruse through. All right. So when you observe that order by Her Ladyship, you would notice that in the text of the order, in paragraphs 1 and other subsequent paragraphs, there are annexures referred to. In total, there are 3 annexures referred to. And those annexures are annexed, rightfully so, to the order. Annexure 1 being lands owned by Yaya Jammeh, containing a first list of about 107 plots and another list that is not itemized, so to speak. It's not numbered, rather. But in total, there were about 153, roughly, plots of land. Annexure 2 would be the accounts, the bank accounts. The first table having 8, subsequent tables having 1 each. On the next page, the first table having 2 and each other table having 1. At the foot of the document, you would see another table with 4, another table which refers to dollar accounts with 4 as well, and so on to Annexure 3. Annexure 3 outlines the companies. Now, from your testimony on Monday, it is clear, is it not, that this information was extracted from the FIU report?
The bank accounts, certainly.
What about the companies and the plots of land?
Well, in our quest to freeze the assets, we, of course, consulted the registrar of companies to identify the companies that we believe belong to the former president or his close associates. And of course, we contacted the Department of Lands to provide us with a list of the landed properties that we believe belong to the former president.
So then, now, just to clear the record, instead of one report, one formal report, at least we know 3 formal reports as we move on. One from the Ministry of Lands, one an internal document from the Registrar General, and the other an extract from the FIU report.
Let me put it this way. The FIU report provided us with the basis to approach the court for a freezing order. But in that freezing order, we needed to identify as much of the assets as at that time as possible, which included the list of land that you have identified as Annexure 1,
deem them as reports?
Well, it's information that was shared with the ministry from these different, yeah.
So you proceeded to the court, attached this information, and you obtained the order. Now, let's begin with Annexure 1. This was provided by the Registrar General. That's the lands owned by Yahya Jammeh.
It would have been a combination of information provided by the Department of Lands and the Registrar General. Yes.
So once you had received that report, was there any confirmation as to whether indeed, perhaps through the Registrar General, that indeed these were lands owned by the former president?
It was provided to us, again, as I said, by the Registrar General and the Department of Lands. Now, obviously, we have to assume that the information that they're providing was accurate.
And the involvement of the Registrar General would be that at least MOJ's confirmation of what was reported.
The Registrar General is part of the MOJ.
Indeed.
Yes.
And that is why I make the statement that at least if the information was derived from the Ministry of Lands, then the MOJ counterpart, that is the Registrar General, could also cross-check in his system to ensure that, yes, the report is accurate.
I assume that would have been the case, but, you know, you are in private practice. You know that the Registrar General still uses an old system of registering title on a, I don't know how to call these huge ledgers, books, but that's still the practice, which we try to change subsequently and try to digitize and try to introduce a digitization of the deeds register. But at the time it was so. I cannot vouch because I understand the challenges of someone going through those big deeds registers to verify. But I would assume that indeed the information would have been confirmed. That would be my working assumption.
Thank you. Just as a segue, by the way, they are now digitized.
We started that there. Yeah, I'm glad to hear that.
That's a good initiative. All right, back to our business for the day. And I want us to proceed to the conception of the commission. Now, can you describe how the idea of establishing a commission of inquiry first arose?
Before I do that, Council, I have had time, Mr. Chair, committee members, to reflect on the activities of the ministry, particularly in the first 3-4 months after the change, because I kept saying on Monday that the assets were not high on my priority list, and that's because we were focused on fundamental governance issues. I have identified, with your permission, some of the activities that we were engaged in the first 3 months only, not even beyond that. So between March, April, and May, I would crave your indulgence. I know I have painted a picture of the logistical challenges. Now I want the committee to appreciate the workload that we had on our plate at the time, to be able to make better judgment of the situation as at that time. And I would just go through briefly a list of the activities at that time in the first 3 months only, because ultimately when we keep referring to the assets, it's a nice way to dress it up, but we're really talking about the livestock and the wild animals here, because the these are immovable properties. They're fixed, they're not going to go anywhere. The vehicles, I have already explained the view of the ministry at the time in terms of the assumption of state ownership. And so what we're left with is the third category of assets, which is the animals. And I keep emphasizing that based on what we had to do, it wasn't very high on my priority list. But I'll just stop at the first 3 months. When I came into the ministry, I was coming in blind. Certainly, I hadn't worked at the ministry for a very long time. I don't recall that any of the lawyers who I found there were working with me back in 1997 to 2000 when I worked there. And so I started by familiarizing myself with ministry staff, because I needed to know who I was working with. I needed to understand their strengths, their experiences, so that I can better allocate.
Mr. Tambedou, if I could just interject there, I don't mean to stop you on your flow. However, I would appeal to the Honorable Chair that at the end of your testimony, we give you as much time as you need to elaborate on issues. The reason why I interject is because you would have noticed that yesterday we couldn't sit for internal reasons, and today we have also started quite late. We have lost a lot of time, and I don't want to have to extend your testimony beyond Friday. But it is becoming a reality, and just as a mark of advice, for us to thrash out the business of the committee, perhaps before the context can come.
But this is fundamental to the business of the committee, because you are ascribing responsibility on the MOJ for the livestock. And I have said on Monday that based on what we had as workload, it was not high on my priority list. This committee needs to know what that workload was so that they could make the determination as to whether we were reasonable in not providing or giving as high a priority to the livestock as perhaps today some would have wanted. I think it's fair for the committee to see what we were going through at that time as a ministry. And I think that's critical. I would shorten it, I would condense them, but I wanted the committee to understand that.
Yes, it is indeed important. I will not water it down. I would, however, prefer that it comes later once we have flashed our business. But I would allow the chair to make a statement, because I can see he wishes.
Thank you, Council. We're just trying to consult. Honorable, in as much as perhaps that wouldn't change what you said earlier on, the committee wouldn't mind to allow you at this briefly to give us a rundown of that. And we will take note, like we said. Council, we can allow him to run that down. We will be able to.
I will try and condense it in 5 minutes, if you like, so that it wouldn't be more than that. But first I needed to, so the first activity I did was to ask for the CVs of all lawyers to be able to determine their levels of experience and how best to make use of their skills. Now that aside, we also had to conceive and conceptualize the transitional justice process. You will be pleased to note that the TJ process that we had in this country was initiated by myself. It wasn't from any outsider. It was based on our own experiences, having worked in post-conflict society. So I was the one who actually introduced the TJ process, conceived the idea, conceptualized it and presented it to cabinet for approval, and cabinet approved it. But we didn't stop there. We wanted to kickstart a process of national dialogue on the transitional justice process. And so I reached out to the UNDP to help fund a national stakeholders conference on human rights and justice. And I believe members of this assembly also participated in that conference back in May 2017. But while we were working on those sort of national policy issues, I had also initiated within the ministry and established a criminal cases and detention review panel, because we were also aware that there were a lot of people who were detained at the Mile 2 prisons who have not had an opportunity to appear before a court, some of whom were there for years, and we wanted to make sure that that was given priority. So I set up a criminal case and detention review panel and gave them 3 months between March and May. And the panel reviewed a total of 241 cases involving 304 persons. We were able to ultimately enter nolle prosequi, discontinue a number of cases through that panel, and ultimately I believe there were about 207 inmates at the remand wing who were still awaiting trial or whose trial were yet to be concluded. But the creation of a criminal case and detention review panel was one of the things that the ministry had prioritized. We had also prioritized, as part of the TJ process, the transitional justice process, the study tour that we undertook in Sierra Leone and South Africa. And so I, together with some other participants from the police, civil society, and the ministry, went on this study tour. But at the same time, Honorable Chair, while all of this is going on, we were also working closely with UNDP to seek the Gambia's access to the UN's peace building fund. Even though we did not strictly qualify because we were not a country that was emerging from conflict, but our situation was analogous to a country that was emerging from conflict. And we needed to access these funds to be able to support the TJ process. And so my ministry was working very closely with the UN office here, particularly the resident coordinator at the time, to make sure that we push forward this, the Gambia's application to be granted peace building funds to support our TJ process. And also at the same time, for the Gambia to be recognized under this UN Secretary General Sustaining Peace agenda. And exceptionally, we were again allowed under the Secretary General Sustaining Peace agenda to support our TJ process. And I am mentioning this because it was important to secure these fundings. Because when the 2017 budget was revised, and you can refer to that budget estimate, our transitional justice process was giving little resources. And I thought it was important because I guess many people, including some of my colleagues, didn't understand the scale and complexity of what we were about to launch in this country. And so I was focused on pushing forward this TJ agenda so that we can have the funds and the support necessary. At the same time, we were engaged in rebuilding our judiciary. We called it the Gambianization of the judiciary. We were involved in that very, very heavily, and all of those activities really made it difficult for us to focus on other matters that were not of immediate concern for us, which is why, if you recall, Mr. Chair, that I had taken the decision to outsource the case of the NIA 9. I had hired a private prosecutor in the person of Mr. Antuman Gay to help prosecute the case of the 9 NIA personnel who were arrested, simply because the ministry was overwhelmed. We didn't have the capacity to cope with all of the activities that were going on at the time. and which is why I also had to seek the support of the UK government, the government of the United Kingdom, through the British High Commission here, to help fund the position of special advisor on transitional justice, because I realized that the Solicitor General on his own, who is dealing with the ministry's day-to-day administration and management, would not be able to cope with the demands of a transitional justice process. So I had to seek support, which was granted, by the way, to me, and I created this post of special advisor on transitional justice to act as coordinator for the TJ process. So just to say that by the time we went to Brussels in May 2017 for the donor conference, we had already completed our 3-year strategic plan on transitional justice. We had shared those with members of the diplomatic community, which is why in Brussels there was so much support for our transitional justice process that one of my colleagues teased me there and said, well, the government is there for my ministry alone, because all the support tended to be for my ministry. So just to say that these were some of the priority activities that we were focused on at the time, and I wanted the committee to put into perspective the issue of the livestock and the need to view the ministry and be fair to the ministry as at that time regarding how much was expected of us to focus on other matters besides governance. Just wanted to provide that for the committee's understanding as well.
That's okay. Thank you so very much, Mr. We'll take note of that. Council, you can proceed. Sorry.
All right. Now, Mr. Tambedou, I feel compelled to fish out some of those, to look into some of those facts anyway. Just one question before we go to my initial question. You have described a scenario where, indeed, and it is notable that the ministry was overwhelmed at the time, and not just the ministry, but yourself. Now, I wish to ask you, which initiative did you begin with amidst all that chaos?
Well, first I had to, as I said, conceptualize our transitional justice process. I have been a keen follower of events in the country, even though I was living abroad. And based on my experience working in a post-conflict society, I knew, and I think the international community also shared this view, that all the factors that could contribute to conflict, violent conflict, in a post-dictatorship era were present. Present in this country. If you look, commonly viewed as the vehicle to which societies transition from conflict or massive human rights violations to more democratic processes. So I am, to answer your question more directly, it was difficult, but I certainly prioritize our transitional justice process, which had several components, which is why I called upon the, I kickstarted the national dialogue through this National Stakeholders Conference on Human Rights and Justice. And there were several topics during that 2-day conference. We invited members of the National Assembly, youth group representatives, women's group representatives, civil society. There were 500 participants, by the way. It was the first of its kind in the country, and I recall the resident coordinator being skeptical about the number, and I insisted, and she was overwhelmed when the number wasn't even sufficient for those who were interested in coming. But it was a way to get buy-in from everybody in the country. And even though we had a strategic plan, we did refine and fine-tune that strategic plan following that National Stakeholders Conference. So in terms of conceiving, I would say it was the TJ process which had several other components.
Yes, but the TJ process would be realized or perceived through commissions.
Yes, the JANNEH Commission was one of them, certainly.
And it indeed was the first.
It was the first major activity. The first activity under the TJ process, if you ask me, would be the Criminal Cases and Detention Review Panel that we started at the ministry, even though that was not in the public eye, but it was important, vitally important, to make sure that those who were deprived liberty and who were still in mile 2, who were the victims of politically motivated prosecutions or persecutions, if you like, including many public officers who were charged with providing false information to a public officer. I can't remember the wording, but there were many public servants who were facing trial, who were in detention. There were many ordinary Gambians who were languishing in prison in mile 2, and that formed a critical component of the TJ process. But that was done internally in the ministry, away from the public glare. But the JANNEH Commission was the first major public engagement of the TJ process.
Yes, I underscore that point because of a question that was put to you on Monday by the Honorable Member for Joshua, Honorable Sirif Saar, and he had asked, was the MOJ ready? And it seemed that the MOJ was ready for the JANNEH Commission because it was the first initiative, at least in the public eye, for your testimony, that the ministry undertook.
If you recall my response to the Honorable Member for Joshua, it was very guarded. I did say we were ready in terms of the personnel and the capacity to set up the commission, but in terms of the wider, broader reform process, I wish we had more time. So I was basically referring to the comprehensive transitional justice process which I had envisioned.
All right. I believe that has been settled. Can we move on to understand how the idea of establishing a commission came about?
It arose from discussions in cabinet. If I am not mistaken, it first arose in the context of the freezing of the assets, in the context of the discussions about the freezing of the assets. But then that morphed into a commission. Are we going to establish a commission? If so, who would be the subject of inquiry? What would be the terms of reference? So it was a cabinet decision to establish the commission, certainly. And I believe the subjects of the inquiry were also discussed in cabinet. Even though the mandate, the terms of reference were left up to the ministry to determine, but clearly the subjects of the inquiry were raised and discussed in cabinet. So the idea started in cabinet.
So who first initiated the discussion? Was it your office, cabinet, or was it the president himself?
It was certainly not me. I can tell you that. I don't recall now who, but the cabinet minutes must be there. These were the discussions in April, May, June. Between April and June, or maybe April and May, the cabinet minutes should, I believe, reflect the discussions, but I can certainly tell you it didn't come from me.
Could it have come from the other two lawyers in cabinet?
I do not recall.
Fair. And you had mentioned that because of your experience, it made sense to go into the transitional justice program. And you also made mention of tapping the experience from other jurisdictions, sister jurisdictions like South Africa. Were there other references?
Yes, South Africa and Sierra Leone. We looked at Ghana, we looked at South America, Colombia, but the two countries that we focus on, which I personally selected to go for the study tour, were South Africa and Sierra Leone. And as I said, I always had my reasons for the decisions that were made at the time.
So what about the commission in itself? Was there consultation with the jurisdiction? I know you mentioned the wider TJ process. But what about the JANNEH Commission?
In terms of setting up the JANNEH Commission,
yes,
we have had an excess of experience of setting commissions in this country. I'm sure those who would recall after the 1994, even though they were not the ideal models, and even after that, there were a lot of commissions that were set up in the country. So the expertise was here. We didn't need to go far for that.
talking about not needing to go far, I would like to ask whether other mechanisms were explored. Perhaps the conventional mechanism of allowing the police or even the FIU, who had already begun gathering evidence as it seemed. Of course, there is also the National Audit Office.
If I wanted to be funny, Council, I would say, why has the National Assembly chose this approach to look into the disposal of the assets and not to other alternative mechanisms?
Because this is the traditional way of finding facts for the National Assembly. In fact, when you go to our standing orders, this is directly what we go to.
Yeah.
And this is the National Assembly breaking in part to report to itself. And that is precisely why. And I'm glad you wish to be funny, because that is precisely where I'm driving at. There were other traditional, much less costly options. So I'm trying to understand, and for you to guide the committee on what made the Commission of Inquiry model ideal.
Well, first, there are several reasons. There are several objectives. But first, I'm sure the committee appreciates that the President has a prerogative to establish the commission under the Constitution. If the President makes the determination that it was in the public interest to establish a commission, he certainly could, and which is what happened in this case. The objectives of the commission are laid out in the legal notice that established the commission. But the fact that it was going to be a commission of inquiry that was accessible to the public was absolutely important. For me, the messaging was as important as the results that we were seeking, because we wanted to demonstrate in a transparent manner the activities of the former president, his financial activities, his financial dealings. We wanted the public to understand the scale of what we were dealing with. We wanted the public to learn in the process about those dealings. And to buttress this point, I recall clearly certain banks were reluctant to appear publicly before the commission because of reputational risks. And I was approached and I turned it down. I said the public interest, the interest of the public to access the information and to see firsthand the proceedings far outweighed any other considerations that they would have. And so there were many objectives. Some of them are contained in the legal notice, as I said, establishing the commission, but there was also a public interest reason as to why a commission of inquiry was set up in the manner that we set it up. It was deliberate, and it was to ensure that the public were informed of the financial dealings of the former president.
So, thank you for that. Was this also the mind of cabinet? Did this discussion ensue in cabinet in that manner?
I believe when cabinet decided to have a commission of inquiry in this public way, that would be part of the objectives.
And how urgent was it to establish this commission?
There was a lot of pressure, as I said, pressure from the public to for the government to be seen to be doing something. And since the other aspects of the transitional justice process required more planning, required more preparation, the JANNEH Commission, as I said on Monday, was the low-hanging fruit of all the major public activities of the TJ process.
Mr. Tambedou, I would concede in saying that if I were in your shoes, I too would prioritize other initiatives over this. However, the fact remains that the JANNEH Commission was the foremost initiative, as it concerns the public at least, the foremost initiative that the MOJ, or rather the government, initiated. Now, you mentioned that it was a low-hanging fruit. But in another breath, going back to your response to Honorable Sar's question, your answer, as you put it, was reserved. And what I deduce from that is there was an element of unpreparedness. Now, I'm trying to reconcile these two statements, it being a low-hanging fruit, yet still having some complex parts to deal with before one engages in it. So could you help the committee, and certainly myself, reconcile this?
I wouldn't describe it as a state of unpreparedness. I think we were prepared to the extent that we can under those circumstances. In terms of personnel, if I had to do it all over again, I would select exactly those personnel who were involved in it, particularly the personnel who had a key role in the process. Now, in terms of other mechanisms of the process, perhaps we could have benefited with from more time on our hands. But that is not to say we were not prepared. I think we were prepared. We were as prepared as we could have been under the circumstances. Let me put it that way.
Fair enough. Let's go back into the halls of cabinet, the discussions that ensued. Now, when such an initiative is proposed, to my mind, all the different policymakers, the ministers rather, would weigh in from their perspective, of course. Now, the Minister of Finance and yourself, the Minister of Justice, should have been key amongst the speakers in cabinet on that fateful day. And I'm trying to understand how the ministers advised His Excellency the President into issuing the legal notice.
Council, this one is a very slippery slope.
Indeed.
In the sense that you appearing to inquire into the decision-making process in cabinet. I'm not sure whether, in principle, that falls within your mandate in this committee. If it does, it makes it difficult for a witness like me who takes an oath as a cabinet minister, including oath of secrecy. And so while I am happy to provide you with the general context, I am mindful of the need to also be guided, because I'm now caught in between two oaths. One oath here to tell the truth, the whole truth, and nothing but the truth. Another oath as a former cabinet minister who was sworn to secrecy and confidentiality. And so there is a limit to what I can share with you in terms of cabinet discussions. But in any event, the fact is, cabinet decided to establish a commission. A commission was established.
Could I weigh in there, Mr. Tambedou? Because it's very important for the record, because the public is watching, to state that, yes, indeed, you did subscribe to an oath of secrecy in cabinet, and you did take an oath here to tell the truth and the whole truth. I don't see a conflict, because where the oath of secrecy was taken in cabinet, and you are protected as far as other institutions are concerned, but you are not protected when it comes to the National Assembly. And I could direct you to the relevant provisions of the Constitution if you wish, or perhaps we can dispense with that and get to business.
I am very conscious of the relevant provisions, both in the Constitution and other relevant laws. The problem is,
perhaps
my evidence is exposed to the public. So it's not just to do with the committee, and that's why sometimes in-camera proceedings are held to redact, if you like, testimonies that ought not to be in the public. So it's got nothing to do with the committee as such, but it's to do with my the public nature of my testimony.
Great. Just like the vision of the JANNEH Commission to be in the public eye, the vision of the National Assembly was for this committee to sit in a very transparent manner in the public eye. But I must say, you do have the right to declare that, or not rather declare, but to request the chair to allow you to make certain evidence in camera where you believe it is sensitive. I do have also the duty to tell you that it remains an application, and it's to be determined by the high table, the members of the assembly. You feel free to make that application.
Just one, maybe, or two comments. The JANNEH Commission also held certain proceedings in camera, just for your information as well. And when the need arose,
we are aware.
But secondly, I want the public to hear my testimony and to hear all of it. And so if it is not on a contentious matter, such as the setting up of a commission, then perhaps we can navigate this and go to more, because like I said, the facts have been established. A commission was established. Whether or not it was influenced by a particular reason or not is, at this point, in my mind, inconsequential, because the fact is a commission was established. So what did we get out of that commission, perhaps, is, to me, what maybe the public wants to know. But in terms of the discussions in cabinet as to who said what,
well, the question is not in relation to exactly who said what. I wish to understand collectively as cabinet, the different masters of portfolio policy, what you advised the president in a wholesome. Now, where I'm getting at, or perhaps what I mean is, the Ministry of Justice would have to advise cabinet on the legality of a commission of inquiry, how it would be set up, how it would be run, how the government envisaged it to be to run, the duration, and etc. Ministry of Finance would advise on the feasibility of such with regards to the economy and whatnot. So that's where I'm coming from.
Yes, that is an ideal situation today, 8 years after the fact. At the time, we didn't have the luxury to sit and think what would be the effect of this on the economy, etc. In fact, if money was allocated to the ministry, including for the TJ process, my role was to do the best I could within the resources available to me. I think that's just the nature of professional environments. You don't always get all the resources you want or you need. If you have to carry out a particular activity, you need to improvise, you need to find ways to meet your objective, and that is what we tried to do with the setting up of the JANNEH Commission. Obviously, it was going to have an effect on the economy, but what we're seeking to derive as a result in the end, one of the objectives was to restore back to the state monies that were misappropriated by the former president and his close associates. So it was a cost and benefit analysis. What was going to be the cost of establishing a commission? What could we potentially benefit as a state from the commission's proceedings? Let's not also forget that for the state to legally take possession of the assets of the former president, there needed to be a process, a legal process to allow that. And the JANNEH Commission was one such process.
All right, I would still go back to the question, but before I do, I just want to make clear the record. You see, in your testimony, you had mentioned a few things. The first is that you were appointed in February, and you were sworn in. You went back in March. I went back and came back sometime in March. Now, from you and I would know that, and the members would also know that the budget is passed in December. Now, you were not even appointed then. Of course, there would be no budget for the TJ process because your genius idea was not on the table yet. In fact, you were not a minister at that time. So I wouldn't accept a response, or rather the committee, I would advise the committee not to take a response, the response that the budget did not provide for the TJ process, because the TJ process was not conceived at the time.
There's just one fundamental flaw in that question.
I mean, allow Honorable to help before we take
Please.
Yes, thank you very much, Council. Thank you, Chair. Yes, what happened is we had a revised budget. When we came into the Parliament, there was already an approved budget for 2017. But due to some of the things the government wanted to do at the time, then the former Minister of Finance actually brought a revised budget that revised the entire actual figures. So essentially, what that means is the new administration actually had their own budget that was actually approved by Parliament.
Yes, certainly. However, we're at the stage.
If I may.
Yeah, just a minute, kindly. We are at the stage of conceiving the commission. It has not yet been conceived yet. And at that point, of course, we will not expect a budget to provide for it when the idea was not conceived. And that is the point. I'm not yet at the approved budget. But please, go on.
And I think that's why I started by saying there's a fundamental flaw in that question, because there was a revised budget, as the Honorable Member for Upper Salem said. The revised budget by the new government provided for the transition, for certain activities in the transitional justice process, which is why I said it was not enough. It was not a lot of money, which is what prompted my action ultimately to start seeking for external funding for the rest of the activities. But at that point, we were still a new government. There were a lot of priority activities in other government departments and ministries as well. Like I said, the government did not, my colleagues at least, did not fully appreciate the scale and complexity of what we were going to embark upon. I did. and the allocations were not sufficient in my view, but we had to make do with what we had.
Yes, and I still insist that my question is intentional. There is no flaw, and I would invite an answer. That at the time that Cabinet was discussing the JANNEH Commission, it would be unreasonable to provide information to say, or rather an answer to say, it was not provided for at the time, because it couldn't have been provided for. It was not conceived yet. That was my point. Now, my question was the nature of advice rendered to the president to warrant him to issue a commission of inquiry. And I'm particularly interested in the MOJ and the Ministry of Finance. The MOJ because of the legal tenets of this endeavor, and the Ministry of Finance because of the structural, financial, and administrative tenets of the commission. And this would have been discussed before any appropriation.
You're making assumptions, Council.
With all due respect, I'm not.
Okay.
Yeah. Please go ahead. I will take your whatever answer you.
So what's the crux? What's the crux of your contention? That there was no budget when we were conceiving the idea of the JANNEH Commission, and by the time it was set up, or there was a budget? Which I'm not sure. I'm not sure I got you clearly.
So my question is not about the budget. I brought the issue of the budget up because you had preferred an answer to the committee to say that there was no budget. There was no budget line at the time.
There was no sufficient allocation of resources at the time.
Yes. But there wouldn't have been sufficient allocation because there was no budget line for the commission at the time. There was nothing allocated for a commission because that commission was not conceived. But that is not my question.
I believe there was a budget line for the commission in 2017 in the revised budget. I mean, I would not put my hand in the fire for it, but I'm just basing on my recollection, and it's something we can quickly verify. But I suspect very strongly there was a budget line for the JANNEH Commission in the 2017 revised.
Certainly there would be some sort of allocation, whether a budget line or a lump sum in the ministry's vote. But we'll get to that. I am not at the stage of the revised budget yet. I am at the stage of the budget that you found when you stepped into office. And of course, that budget could have not foreseen that Mr. Abubakar Tambedou, with his brilliance, would conceive a commission. So that is not a question. We're going to get to the revised budget. But for now, we're talking about when you came into office. Yes, there was a budget line. You could see that with the ideas you were preferring, the budget line was insufficient. So I wish to understand how debate ensued in cabinet, the result of the debate, of course, not the actual debate, to warrant the appropriation in the subsequent revise.
Well, there were discussions in cabinet. It was not a one-day discussion. Those discussions took several days and weeks, if you like. We always had a packed agenda. I recall we would sit in cabinet until midnight on occasions at the start, because there were a whole host of issues to deal with, including issues about the commission. So the commission was not the only subject of discussion in cabinet, and so and the final decision taken to set up a commission was not done through one cabinet meeting. There were a series of cabinet meetings, and along the line, of course, in tandem, there were discussions about a revised budget, and so the two went far apart. I'm not sure if I am answering your question, or maybe I still do not understand what you mean.
Well, you have answered it in part, but I still wish to understand what advice you proffered to His Excellency from a legal standpoint. Indulge me, it will make sense.
Oh, I carried out cabinet's instructions to help set up a commission of inquiry.
Yes, but the cabinet relies on the Minister of Justice to advise it on issues of law and justice, constitutionality, etc.
Yes, and there was nothing unconstitutional about setting up a commission.
And the suggestion is not that there was. The question is, what was the nature of the advice? Perhaps let me go a bit more direct. Did you advise the President on the scope and powers of the commission?
No, that was left to the ministry to determine. Based,
Which
like
ministry?
I said, with the Minister of Justice, which is why I said the subject of the commission's inquiry or the subjects were discussed, but not the operational aspects of it in terms of the terms of reference and the scope.
So precisely that the Ministry of Justice, and of course the ministry can't sit in cabinet, it is the Minister of Justice who would sit in cabinet. So let me rephrase that. The Minister of Justice would advise the President on the scope and powers of the commission.
Yes, the President was briefed
Yes.
when the commission was being set up. That's right.
And of course he would understand that commissions are generally independent, and they would report back to him once the tenets of his instructions were carried out, etc.
Not just generally independent, they ought to be independent.
Indeed. And then that is perhaps where the Ministry of Finance would pick it up from, to ensure that that legal advice is accompanied with some sort of financial advice. After marrying the two, you would get indeed a practical independent commission.
Are you suggesting that in the absence of the Ministry of Finance providing autonomous financial support to the commission, then the commission was not independent as such? Is that the insinuation here?
I'm limiting my question to advice to cabinet as at the moment, and we will get to that bit shortly.
I don't recall that discussion ever taking place in cabinet.
Okay. But the